Hi, this is Rick Frederick talking about Davis v. U.S., a 1895 case. Although the Supreme Court doesn't recognize a constitutional principle for the insanity defense, doesn't say that it has to exist or say what it is, there are many federal cases in which people claim insanity, and there are due process issues that arise from the use of the insanity defense. So there are times in which the Supreme Court will comment on or make law with respect to the use of the insanity defense. So one of the first cases here is this 1895 case in which happened in Indian Territory, which makes it a federal case. Now, what is it's Davis' very simple case. Basically, the trial court said that because Davis raised the issue of insanity, he had the responsibility to prove that he was insane. And so this is what the issue is: the presumption of sanity constitutional. So that's what Davis was presented with. He was presumed to be sane. He was presumed to be sane, and it was his responsibility to overturn that presumption. Or should sanity be considered an element of the defense which the prosecution must prove? So the Supreme Court says there's no problem with the presumption of sanity. That if you then require the prosecution to prove everybody is sane who has a crime involving intent, that would add a big burden to the prosecution. So the presumption of sanity is sensible, practical, but it's not a conclusive presumption, but rather a rebuttable one. So when there's evidence of insanity, is really what this should say, when evidence of insanity is introduced, and it falls upon the government, the prosecution, to prove that the requisite mental state existed within the accused. And then it becomes an element of the offense. It's not just there was intent, but also there was sanity. So this burden, it's fair to put it on the prosecution. Which is exactly what this analysis says. If the evidence was equivocal, the Supreme Court concluded that the prosecution must consider requisite mental state as an element of the offense to be specifically proven beyond a reasonable doubt. So the burden's on the prosecution. So in this case, Davis was unfairly treated by having to prove that he was insane, where it was the prosecution's burden to prove that he was sane. All right. Oh, well, I guess there's more analysis here. Requiring a defendant to prove that he or she is insane is tantamount to abandoning the presumption of innocence. Such a scheme is unconstitutional. I don't think there's anything new there. Okay, thank you very much.